For most of us, what constitutes a de facto relationship is pretty clear cut. But when it comes to the courts, it isn't quite so clear cut.
Every day, the courts hear disputes about whether or not a couple was in a de facto relationship to determine if a property settlement or application for spousal maintenance can be filed.
Ultimately, the decision is at the judge's discretion, but there are a variety of considerations they take into account. These include the length of the relationship, which generally needs to include 2 or more years living together as a couple.
But not necessarily exclusively or full-time.
Not at all. There are many instances where the courts have actually considered extramarital affairs to be de facto relationships.
They also take into account things like whether a sexual relationship existed, if there were children involved, and financial aspects, like how living costs were shared and whether there were joint accounts or shared assets.
Along with whether or not family or friends consider them to be a couple. And things that actually show a mutual commitment to a shared life, like going out together, holidaying, and saving for a property.
Yes, when it comes to the courts, what constitutes a de facto relationship is certainly not cut and dry.
If you're in a de facto relationship, about to start one, or even having an extramarital affair, it's well worth having a cohabitation agreement drawn up. Cohabitation agreement is a bit like a prenup. It sets out the assets that each of you bring into the relationship and formalises how you intend to divide them if you separate down the track.
It not only helps to protect your assets for you and your children, but it also helps to minimise conflict if things don't work out.
We have extensive experience in this area and can provide you with advice if you're entering into or ending a de facto relationship.